Good morning, friends. Sat Sri Akal, Namaskar, and Adab. This is in continuation my 193rd video, and this video will cover an exclusive topic of the Sit Sutlej state. Now, people may ask me, Ronnie ji, why Sit Sutlej state? Now, Sit Sutlej state actually meant by the word Sis was Jamna, so lands above Jamna, and Sutlej meant where the Punjab and above was the Punjab territory of Maharaja Ranjit Singh, and below of Sutlej. So you go up till from where Sutlej comes, Manali, Mandi, all these territories. Going down the road, it enters into Punjab. So Firozpur, Ambala cantonment, Kasauli, Dakshai, and Sabatu. So these are the cantonments, even Jitok. So these are the cantonments which fell in the Sit Sutlej state. So now from the what I just told you, how the treaties were made, now I talk of the Punjab Land Administration Manual. And on page 38, what does it say? History of Jagir tenures in Sit Sutlej state. Now section 100. The Jagir tenures of the district formerly known as Sit Sutlej state have a history of their own. No better account of Ambala Gastia which will reproduce the whole story. The Sikh conquest, the storm bursted in somewhere in 1763. The Sikhs of the Maja countries, Afghan governor Zain Khan occupied the whole country to Jamna without further opposition. Traditions still described how the Sikhs dispersed as soon as the battle was won, and how riding day and night each horseman would throw his belt and scrapped his articles of dress and accoutrements until he was almost naked in successive village to mark them of his. The chief hastily divided up among themselves their followers the country to the Jamna and asserted themselves to be the rulers of the people. In a very few cases, such of those as Sayyid Mir of Kota and the Raipur and Ramgarh, Rajput Sardars of Narayangarh, and the Baridwan Jat Sardars of Kharad, the indigenous leaders of the country were strong enough to hold their honor in any fashion and to assimilate their position of that as a conqueror. Elsewhere, the Sikh rules was supreme in the experience undergoing by the mark of the country to the present day. So now this formation of this Sikh terrain of the Sit Sutlej was taking the state of country before the chiefs were taken under British protection. The history for next 40 years is made up of the endless party warfare of these independent Sikh chiefs among themselves, except when a common danger banded them to resist the encroachment of the more powerful states of Patiala, Mani Majra on the north, and Ladwa, Kethal, and the Thans of the south, each separate family and each group of feudatories, strong enough to stand alone, built itself a strong fort as a center from which it could bury the whole neighborhood. Many of these are still in existence and marked features of the districts, recalling the extraordinary lawlessness of the period when literally every man hand was turned against his brother. No attention was paid to the country by the British government. This is of 1783 period. The British government, which had foxed Jamna as the furthest limit to its political enterprises. So, the Britishers did not want to move ahead of Jamna, that is the Marathas or the Sindhya state. This was the Gwalior. And it's believed that the profoundest ignorance prevailed between brothers as to the constitution the rights and the political strength of those supposed to be rulers. The Sutlej state was finally taken under protection in 1809. So from 1806 to 1808, the position rapidly changed. On the one hand, the Sutlej chiefs themselves were panic-struck at the sudden danger threatened to them by the rise of Maharaja Ranjit Singh's power beyond the Sutlej. In the 3 successive years of 1806 to 1808, raids were made by Ranjit Singh in person to Ludhiana, to Narayangarh and to Ambala. It was openly announced by him that he intended swallowing up the whole of country to the Jamuna, and it was realized that one power and one only could prevent them from this suppression. On the other hand, the British government feared a new danger from the not so combined invasion of the French, the risk and the Persians, and it was hastily decided to give up Jamuna as the boundary and trust to the new principle of alliance with a strong buffer state at Lahore. So try and understand the historical perspective. At the same time, it was recognized that Ranjit Singh was himself a source of danger, not to be despised, and with the government in the mood in 1808. Exact date March 1808. An impulse was easily given to the policy of active interference of the arrival at Delhi, and the deputation and representations made by the Raja of Jind, Patiala, Kaithal, the invoking and the assistance of the Sutlej treaty was done. Now finally this treaty is made in 1809. It was apparently assumed that the whole territory to the Sutlej was parcelled out among a few leading states of the same character through whom the country could be strongly governed, hence securing an effective alliance with Ranjit Singh, on the other hand, extending British protection to the lesser states, smaller Rajas between the Jamuna and the Sutlej. The overtures were eventually successful, and a definite treaty was made with Maharaja Ranjit Singh on 25th April 1809, by which he surrendered his new acquisitions south of the bank of the river of Sutlej. The treaty was followed up by May 1809 by the celebrated proclamation of the Colonel Ochterlony on behalf of British government to the Sutlej chiefs. So friends, we need to understand this proclamation, which clearly gave the sovereign rights to these chiefs. Now at page 122 of the book called Punjab Rajas, it included 7 short articles. Only of importance were number 1 to 5, and more important was 1 to 3, which limited Ranjit Singh's power and declared Chief Sutlej state as sole owners of their required rights. So the only in return remuneration taken by the British was that the British will be assisted and would be given forces, animals, bullock carts when any war is to be deemed to take place by the British Army against anybody other than Sutlej state. So Sutlej states not understood when protection was granted. It was impossible to read history of this transaction without belonging to the government, where in reality taking a most important step, most in the dark, instead of finding the Ambala territory under the control of few central states, they soon realized that they had given it over forever to hordes of adventurers with no power of cohesion, who aimed only at mutual aggression and whose sole idea of government was to grind down the people of the country to the utmost limit of oppression. This first point was easily settled by a sharp reminder given in a supplement and proclamation of 1811, that every man would have to be content with what he held in 1809, and the British government would to legate no fighting among themselves. It was, however, found that as a fact, the so-called Sutlej sovereign states were represented, as far as Ambala was concerned, by some 30 petty rulers with estates ranging from 20 to over 100 villages, and by a host of small fraternities comprising in many hundreds of ranks and files among the followers of the original conquerors, who had been quartered over the country with separate villages for their maintenances. So this is the formation of this entire Ambala district. Small petty chiefs became rulers of there. Now I would just share it. I remember we had we had a photo of Ramgarh, Kot Billa, Narayangarh. These are very small villages. So these proclamations, published work, have nowhere very clearly recognized how surely the government, repented of its mistake. But there seems no doubt as to the facts, and it is not to be wondered at that Sir David Chitterling should have Ochterlony should have privately admitted to the Governor General in 1818 that the proclamation of 1809 had been based on an erroneous idea. So now the British were feeling the heat that the treaty which they made was not giving them the result which they were looking for. So the relations between the British government and the Sutlej state during this period of 1809 and 1847 was getting fragmented. Persistent efforts were made to enforce a good governance, though the political agent at Ambala among themselves considered himself a more independent state. The record of time bear witness to the hopes nature of the undertaking. They teemed with reference to the difficult inquiries necessitated by the frequent disputes among the principalities, like those Rajas or their further petty Rajas. So this kept happening. So year by year, government was driven in a self-defense to tighten the reins, and every opportunity was taken to strengthen its hold on the country. So now the Britishers gradually were moving from the protection to taking back that by enforcing its claims to lapse by skeet on the death without lenient heirs of the processors of 1809. It was thus the British district of Ambala gradually grew up, each successive lapse being made the occasion of regular settlements of 1809. Each chief, great or small alike, had within his own territory the same absolute civil, criminal, fiscal jurisdiction, subject to the Governor General or the agent. The right of skeet was the sole return for its protection, which the government demanded. Where these two things changed, earlier they were asking for forces, men, warriors, bullock carts, animals, horses. So things kept changing. Sutlej chief who were complete immunity from evasion of Maharaja Ranjit Singh, and they retained their unlimited rights of sovereignty. So this was not likened by the British by 1846 or 47. So they started now the misconduct in Sutlej state. So the first Sikh war in 1846-47, a fresh step had to be taken owing to the passive obstruction or open hostility on part of the chiefs when called on to assist the government with supplies of men during the war or transition of Sutlej 6 in 18. No occasion had occurred for testing their gratitudes for the benefits secured to them until the declaration of First Sikh War and Sutlej campaign of 1845. But when tested, it miserably failed. So now the British government knew that the chiefs were not supporting them. So finally, this was now being changed. So we have to now understand what actually is happening. So the chiefs and its fraternity, those smaller petiers, were reduced to the positioning of the Jagirdars. Now, since they were losing the confidence of the British, the Sikh chiefs fortified to claim their considerations. It was seen several important measures were at once adopted. The police jurisdiction of most of the chiefs was abolished, the existing system being most unfavorable to the detection of punishments of the charmaris or the furtherons. All transit and custom duties were also abolished. And thirdly, a commutation was accepted for the purgold services of the chiefs and his contingents. The dispatch of Governor General embodying this resolution was dated 17th November 1846. So the only states which were exempted by this order were Patiala, Jind, Nabha, Faridkot, Malerkotla, Chacharoli, this is Kalsia state, Raikot, Buria and Mahmud. So these were the states, I would put it, who fell to the British rule. And the rest, Jind, Nabha, Kangra, Semur or whatever, they did not. So with the exceptions, now the European officers started doing the policing in Ambala. And in Ambala, we had in 1846 or 45, we had a commissionerate being built. So now we had a regular commissionerate from Ambala. And you'll be surprised, friend. Ambala district started from Sutlej, went up till Lahaul Spiti. Entire Shimla, Sirmur, Nahan, Jamna belt till Delhi. Borders of Delhi, Jamna, Jind, Nabha, entire now Punjab of India and Haryana. So this is how it happens. As regard to minor chiefs, the same thing kept happening. And for a short time, an attempt was made to leave them to unrestricted right of collection of revenue of their villages in kind or thereto. So the British has played very smart. They said, okay, fine, let these chiefs take revenue from their Pattidas, Jagirdars or Mufsidas and whatever they want to do, let them do it. So this was basically, they were trying to trouble the Pattidas and the Jamindars from the original chiefs. So this in June 1849, it was accordingly declared that with the exception of states, already powers should all lose criminal, civil and fiscal jurisdiction and should be considered on most certain exception privilege. The revenues were still to be there but were assessed by British officers. So the revenue settlements 1852 and 1847 of the villages, they have sunk to the positions of Jagirdars, but as such retain a right to revenue assigned to them in perpetuity. Now we will read section 101, commutation of military services, required by the 5th clause of the proclamation of 3rd May 1809, was fixed at ₹16 per mens for every horseman and 6 per mess for every footman. This, however, was changed in 1852 into a drawback of 2 annas per rupee, a revenue on Jagir estate. This is generally the rate, but in some cases 4 annas and 8 annas are taken. And in few Jagirs, the commutation was reduced to 1 anna on account of services rendered in the mutiny of 1857. Now coming to section 102, peculiar stand of Sit Sutlej Jagirdars. The Jagirs in this Sit Sutlej state are not the gift of the British government, as are those in part of Punjab which was annexed after the Second Sikh War. Nor do they stand on the same footing as the conquest Jagirs in the tract between Beas and Sutlej, the holders of which are descendants of men whether originally independent or not were subjects of the Rajas of Lahore before they came under British rule. But the Sikhs in the Sit Sutlej state, whom we transformed into Jagirdars in 1847, however petty their individual holdings might be, were in theory and to a large extent in practice independent rulers whose ancestors had come under our protection of 1809 with a guarantee that they would remain in the exercise of the same right and authority which they had thereto enjoyed. It was indeed proposed in 1846 after the First Sikh War to declare all estates forfeit of accounts of the lachas of their holders and re-grant them under sanads. So what were the old grants going in to be? Re-granted from the British government. So Lord Hardinge deemed it impolite to proclaim to all India the misconduct of Sit Sutlej chiefs and negated the proposal. In a sense, then the Sit Sutlej Jagirdars, however great or small or mediated rulers, and little though they have, a body deserved at our hand, this fact should not be lost in sight in our dealings with them. Section 103, classification of Sit Sutlej Jagirdars. The Jagirs are classified in three forms: the larger states, the Pattidari Jagirs and the Zaildari Jagirs. There is no difficulty to the general meaning of these terms, though questions have risen as to whether a particular Jagir would be put in the second or third class, and no authority list of larger estate has been ever drawn up. Now what does this larger state means? Now section 104 in the manual explains. Larger states are Jagirs possessed by individual sharers or their descendants and including a larger or a smaller number of villages. The Pattidars and the Zaildari Jagirs are held by fraternities or consisting of the dependents of bodies of horsemen who overran the country when it was first conquered, or those who were called in later to help the original conquerors to hold back their estates. So, were they maintained or acquired a position independent of great Sardars? Their tenures are known as Pattidari Jagirs. Where their holdings were subordinate of those of Sardars who claimed the right to lapse of hairless shares, they were called Zaildari Jagirs. So now they are briefing these. So now the customary laws or the wazibul laws regulating successions, tenures of the Sit Sutlej state in a period of 1851. The best source of information as the rules governing the succession of the state acquired by the Sikh conquerors of the Sit Sutlej before we reduce them to the status of Jagirdar is now Mr. Sir Lapel Griffin, Law of Inheritance of Chiefship are as observed the Sikh previous to the annexation of Punjab, published in 1869. In these stormy years of 1809 to there, sometimes made work or hereditary titles existed, but the conclusion was drawn by Lepel Griffin by recording is that the real rule of succession was identical with that prescribed by the customary laws in Vazibulas, that the descendant of landed properties in the Punjab. It was but natural that peasants who had suddenly found themselves provinces should apply to their conquerors the only law of inheritance with which they were familiar. So people were known to those original customary laws that if they die, and since their grant had to be reverted back to the king or the ruler, it is noteworthy how often between the date of conquest and 1847, the title of the sonless widow to succeed to the enjoyment of wide possession and authority was admitted. Let's say if there is a widow and she doesn't have a son. When the rights were overridden, this was frequently managed in a perfectly legal way, still customary through large part of Punjab, by means of a lacuna marriage between the widow and her deceased brother. If you remember, there was a movie called Chaddar, like the younger brother of the bhabi or the daughter-in-law of the house would marry her or him, let's put it this way. So these Jagirdars, their inheritance, every ships were retained. Now talking of Pattidari Jagirdars, rules were explained as a matter in which the tenure of Zeldars and their holders of larger estates differ from the format that of a Pattidar who will not be noticed as a larger state. So what is the succession of these Pattidar Jagirdars? In 1851, the government of India laid down three following rules regulating the accession of horsemen, shares in Pattidari Jagirdari. This is now a widow shall succeed, that no descendants in the pedigree line shall inherit, that on failure of direct male heir, a collateral male heir may succeed if the common ancestor of the deceased and the collateral claimant was in possession of share at the source and period of 1808 and 9. Let's say there were two brothers. Now one who was the king, being the eldest, does not have a male member. This was the existing holders were not entitled under these rules to retain possession of their lives if and receive pensions if females were there. So Lord Dalhousie, through a rule, laid down the variance with the courses which had been actually taken in many cases. The Governor General would by no means disturb the decision which had been given. All parties who received pension from the British officers should retain it for their lives, except females who should receive pension instead. Let's say there is a widow of a ruler. I have a case of 1873 notified in the DC Gazetteer of Ambala. So this is referred to a proposal by a bear that widows and daughters should be given money pension, not exceeding half their husband or father's share. In 1853, the Government of India decided that the title in perpetuity could not be acquired through females, but that male who had inherited through females would be left in possession of the share in the life. So all these lands or grants were in perpetuity. Now rules not applicable to which part of Sutlej territory annexed after first Sikh war, that was in 1840. The rule do not apply to the conquest on the right bank of Sutlej made by Maharaja Ranjit Singh. Now, right bank was above which, where dependents like Fateh Singh Ahluwalia of Kapurthala, who in March 1808 retained through the treaty on 25th April 1809. So these paras are detailed in format for every Raja at that time in this book. So I'm not going to read the whole thing. The remarks on the rules. 1851 was seemingly not in accordance with the custom, which would have given a sonless widow a life interest in her husband's share. But if any injustice were done, it was redressed by the Board of Directors, who in 1854 ordered that widows who had been dispossessed should have their pension raised so as to equal the jagir. So Sir John Lawrence and Mr. Mansell, the President Sir Henry Lawrence, preferred the principle which had been followed in deciding the succession of large states of Jind and Kaithal, namely, that without any reference to the state of possession of 1809, a male descendant of the first conqueror of an occupant should inherit all that had been acquired by the family head of the family before the collateral branch split into the form of stock. So there were states which splitted. Family customs were held, but they were inconsistent. So there were so many things which kept happening during this period when you read the Sutlej state book. So Mr. Edmonston, the commissioner of Sutlej state, who sanctioned the Board of Revenue Officers in 1852. Now this is reproduced in Appendix 3. The settlement officer, it was not only necessary to quote for them here that a specific order of government, even though opposed by the principles and rules now prescribed, shall avail in favor of the party concerned and his lenient male heir, that the official and recorded declaration of the political agent as to the person in possession in 1800 shall be accepted without question, and succession continued accordingly, that alienation by a jagirdar or a pattidar of a portion of his holding, whether to his relation or strainer, shall neither be officially recognized nor officially recorded. So that means sale was not allowed of these lands. That one or more son of a common ancestor from 1808-9 being entitled to the whole share possessed as a common ancestor shall be held and declared responsible for maintenance if there is a window left by the deceased brother who had then lived and had shared his produce or lagan with or the revenue with his son or sons. So investigations of the Pattidar Jagirdars and regular settlements of Sutlej state was carried on. The revision in Jagir register of Ambala and Karnal, which raised these settlements. At the revise of these settlements, it is very important to state what actually happened. So in Karnal, when originally the cantonment was being made, Mr. Dow made a Jagirdar register, and he even created the same register for Ambala. Kaithal and Ambala were there. So the new register is more compact, convenient, what he says. Now this register is lying in Karnal, is lying in Kaithal. These include all the three classes of Sutlej Jagirs. The condition of each Jagir was in reference was ordered, determined. The rate of commutation was even recorded, noted. The genealogical tree of each family showing the existing descendants of the person in possession in 1808-9. And the right of succession, list of giving names of shareholders till 1888 is lying with fraction representations, his share and the value of that fraction. So these are those records, how pensions had to go to these Jagirs. So this register is of very importance. I tried in the Karnal Registry Office, the DRO, but I couldn't lay my hands on it. So the ruling regarding Zaildari Jagir, already indicated between Pattidaris and Zaildari Jagir, is that lapse in the former benefits government, while lapse in the later accrues to a larger state. It was ruled in 1852 by Sir Edmund that the inquiry then being made into Pattidar Jagir tenures should not extend to the possession of the Zaildars or dependents of any individual Sardar during his lifetime. Second, that an estate of that Sardar lapsing, the possession of his Zaildari should be inquired into, ascertained and recorded, and that from and after that date of lapse, the Sardar estate, lapse of the Zaildar shares of succession to the same state should be followed in first and second in the rupees prescribed in the government order number 461 dated 12th February 1851. Meaning of the second rule, the word second of these rules is not explicit, but it seems clear that Mr. Edmonton meaning was that the case of Zaildari Jagir dependent on a large estate, the inquiry should only go back to the possession as it stood the time when the large estate lapsed, extended to succession, which had taken place since. This was the course actually adopted in the days of Zaildaris, and the diagraph, like the pedigree set up, which lapsed about that time. Mr. Edmonton made a proposal. They were given the status of 1852. The intention of the rule was either overlooked or misunderstood, for at the first regular settlement of Ambala and Thanes, the Zaildars of several lapsed estates were given the status of 1809, 8 and 9, and has been decided that the orders then passed shall not be disturbed. So it is very clear that this rule 2 was very clearly saying that even if there was a mistake, the proprietorships of the large estates will remain. Now, status of 1847 given to Zaildars of the large estates in existence in 1854. The Chief Commissioner, at the suggestion of Mr. Edmonton, who had become Financial Commissioner, modified these two rules relating to the Zaildari tenures quoted above and decided that 1847, the year in which the Sardars were deprived of sovereign powers, should be assumed as the basis of adjudication in all disputes between Jagirdars and Zaildars and further shareholders in the dock. So the reason of taking the date 1847 instead of 1809 was to protect the Zaildars from harsh claims on part of the Sardars. It was felt that endless disputes and claims would arise if the status of 1808 and 9 were taken as defining the tenures of the former chiefs, the 36 chiefs which I told you, were prejudiced towards the larger estates of these Zaildars. So the existence was taken from this period of 1847. Now this peculiarity of the regulation is a succession. So in cases of Jagirs of Maharaja in Firozpur now, see friends, I am talking of Sutlej state. I would even talk of Kasauli, even talk of these cantonments in Himachal, Dakshai, Sabatu, Firozpur, Ambala. This is the Sutlej state. The numerous porous peasants, Jagirdars, of Maharaja and Bucho Mandi in Firozpur, who claim kingmanship with the great Fulkan Rajas of the houses, own their Jagirs holding and having a peculiar rules of their own. So their Vazibulars was something different. Government has given up its rights to lapse in consideration of a petty increase in the rate of commutation payable by the succession followers. See, now the Britishers here were playing a divide and rule. So they were only looking for the revenue. So they gradually rose the revenue of these petty chiefs, or the tillers, I would use the word. So the law of inheritance was made applicable on these landed states in Firozpur. Hence, widows enjoy their husband's share so as they refrain from a second marriage. Works done. No absolute rules prescribed to regulate successions of larger states. This was also discussed. Now, 1851, Lord Dalhousie stated that no absolute rule is there to seize a large estate. Each case may be taken up on an individual manner, and with the great advantage of determining on its merits how easy and difficult it was to inherit or transfer the estate to the next. His Lordship would, however, remark generally that consideration of the customs of families should have been preponderating influence in the decision of such cases. Such estates were therefore excluded from the format inquiry which the settlement officer was directed to make regarding Pattidar Jagirdar, and the board ordered that each demise should be reported with a statement of customs of the family. Meaning there, what is large estate? Some difficulty was felt by Sir Edmonton in defining these large estates, friend. I presume, he says, that large estate was meant to comprehend such estate as Burial, Shahzadpur, Mani Majra, Sailaba and others which were held not only by fraternities of Pattidaris as the Pattidars of Bilaspur, Sadhaura, Tirwara, Ambala, Bo, for instance. These were the fractional horsemen shareholders in individual capacities of the then Sardar chiefs of the Sutlej state. I find it difficult to propose any definition of term large state, and am compelled therefore to exemplify my meaning if the board concur with me in thinking that the term is not exclusively applicable to the 9 sovereign states. It might be sufficient to declare generally that the orders communicated with your letter above referred to are applicable only to states which are held by fraternities of Pattidars and in which the distribution of holding according to horsemen shares is recognized, leaving any case which may admit of doubt after the declaration of this principle to be specially reported under the rules and estates which had been exempted during the period of 1808 and 9. The board accepted the correct Mr. Edmonton's view on page 120. It is stated that Mr. Brackley's direction to the settlement officer. Now, how far was these large states applicability of 1808-9 taken? That no absolute prescribed form of guidance from the government was available has almost invariably been referred to as claiming governing of a collectoral state which could be called a large state, the custom of the family being referred to only to determine whether the state should descend integrally or be divided among the nearest heirs, either in equal or unequal shares. What provision should be made for widows and others? Points of these were to be discussed. Few precedents were available in 1859, which the Commissioner of Sutlej State, in a letter dealing specially with large states, writing, said, "We have taken the status of 1809 AD and have declared all Jagirs separately, held at the date as separate fields inheritable only in a direct main line." So there are two different views now, but it seems doubtful if the question whether the status of 1808-9 does or does not govern succession of large states Now, Sir Edmonton had given a different rule. Has often been a very few large states have lapsed in default of direct heirs, though it is a notion that and some cases the present Jagirdars are unrelated either to the original conqueror during the period of the Sardar chiefs of 1808-9. So no shame has been felt in foisting on government superstitious heirs when the succession to a Jagir was endangered by want of issue. So this is what the petty chiefs were even doing. They were illegally or legally, they were trying to create heirs. Date of adoption decided question who arise possession since 1800. No question like this arose in Pattidar Jagirs, as the exact date referred in the phrase, the status of 1808-9, the record of person in possession made at the first regular settlement would be reacted as finally deciding form, who the claimant must trace the descendants in order to inherit a share. But now coming here, large estates were exempted under an inquiry of 1851 by Mr. Edmonton, and the status of 1808-9 in determining the succession of large estate, it may be necessary to decide who was in possession at a particular date in the period loosely described in 1808 and 9. In such cases, the best date of adoption is March 1808. That being the month in which the principal Sutlej chiefs formally applied for protections to the British government. So the whole topic is on a settlement of British estates. Now finally the customs which govern the succession of these large estates. Lord Dalhousie directed that special attention should be given to family customs. Premature will be followed where it is establisher's custom, as it is in the case of the Pathan Nawabs of the Kunjpura and in the case of Rajput Jagirdar's family of Raipur. It is probably that the Jats or the Khatri Sikhs had always been treated as an ordinary Jagirdar. So there was some discrimination. Now came the Charmari tenure in Tahsils, the Nazir of the Karnal districts. So this we really don't need to discuss because Karnal was abundant as a cantonment, and finally Ambala became the cantonment. But yes, the Charmaris and the Zaildars were given their rights. Now he says the Sidh Sutlej Khalsa state had some territorial Khalsas. Ordinarily, the Mafs of the Khalsa states governed by the same rules as those of Punjab province. The case of these mafias in Jagirs and shared estates will be noticed later. So friends, we have to understand what are we actually looking in for. What are we actually coding into? What Sidh Sutlej state as a whole, in which these 6 cantonments fall. How territorial Jagirdaris, Charmaris, Musfidaris, Pattidaris, Jagirdars, Zaildars and the petty chief Rajas of 1808-9 status were given proprietorships. So this is one set of Sidh Sutlej state topic. In my coming video, we will again discuss Sidh Sutlej state in a different format from different gazetteers and ledgers and books on Sidh Sutlej state. Thank you. Good day.